Good morning. Thank you all for joining our education class today. My name is Julia Jiang from Coldwell Banker Dynasty. I have the great honor to serve as your 2025 Education Committee member. A few housekeeping tips before the class starting. Please silence your cell phone. If you need to answer your phone calls during the class, please walk out to the hallway. So at this time, I would like to introduce our special speaker today, William Haar. William Haar is an estate planning attorney based in California and also licensed to practice law in New Mexico. He has been licensed since 2008 and began his legal career practicing in a range of areas before narrowing his focus to estate planning. Between legal roles, William took a long hiatus from law to pursue a career in software development before ultimately returning to legal practice. His diverse professional background informs his thoughtful and client-centered approach to estate planning. He's passionate about building relationships with individuals and their families, helping them preserve their legacies and make informed decisions about their future. William lives in Whittier, California, with his wife and his two sons. Now, please help me to give a very welcome to William Haar to present today's topic, how to avoid probate at death. Thank you.
Thanks so much for that warm introduction. Good morning, everybody. My name is William Ha. So I want to thank the Education Committee for having me here to speak today. I think real estate agents are actually on the front lines when it comes to this type of stuff. Oftentimes, whenever I have a prospective client who wants to do a probate or anything, it's not often that they call the probate attorney. It's rather they call the real estate agent who they've already developed a relationship with in the first place. So you guys often are the first people to try to solve the problems, and then you basically broker the introduction to people who can absolutely help them out. So this is me. My name is William Ha. I'm an estate planning attorney. I do wills and trusts, and I help people avoid the probate process, although I do probate as well. I mean, a lot of these terms you guys are not unfamiliar with because you guys are real estate agents, but it might be a little refresher, I'm sure. So I ended up picking up a license in the state of New Mexico because my wife, she's a physician. She got a job out right before COVID at a critical access hospital in this small town in New Mexico. So at that time, I ended up taking a brand new bar exam, got licensed out there, and I went ahead and practiced general law. I did criminal law, civil law, family law, estate planning, bankruptcies, everything. And that process actually rekindled my passion for law practice. And what brought us back here was because to birth my son, he has a severe and rare form of epilepsy, which is why we needed a standard higher medical care. But he's one of my whys, why I do estate planning, and what my mindset is when it comes to practice. Okay, so you guys have seen attorneys talk before here and elsewhere. Basically, the whole idea is that this is a disclaimer, nothing here is legal advice, and that it's all just legal information. Okay, so why do I want to give this topic about how to avoid probate without hiring an attorney and also without doing a trust? Am I trying to put myself out of business along with other of my colleagues? Not really, right? So I think the reason why I'm doing this is because for the bulk of people out there who are curious about estate planning or they know that they have to get it done, the reason why they don't get it done is because they think they have to have a certain amount of wealth to justify it, or that it's really, really complicated. And because they think this way, they never do it. It's too late. You know, I get calls all the time from kids who say, "Oh, my dad's in the hospital. He's on life support. We don't know how long." And I said, I can't help you because it's too late. The round trip to do estate planning on average might take about 2 to 3 months. The fastest full-blown estate plan I've ever done for anyone was 6 days, but they were very motivated. They had the money ready to go. They had the capacity. And most people do not have the capacity by the time they are at the hospital. So this stuff is stuff you have to do well in advance. And what I'm trying to do is I'm trying to go through the basic mechanics of how this could be done without hiring an attorney, without doing a trust, so that I'm hoping that this will make it so that you guys understand that this is very doable. And by understanding the mechanics, that it would encourage you guys or your clients to seek out help with an attorney, and that estate planning really is for everyone, not just for the wealthy. Okay, so my favorite quote and idea about property ownership is this right here. The things you own, they end up owning you. And this phrase was spoken by a fictional character named Tyler Durden from the 1999 movie called Fight Club, starring Brad Pitt and Edward Norton. And the reason why I like this phrase is not that I'm trying to advocate for you guys to own nothing, but rather that this phrase conveys how deceptively true that how deceptively expensive property ownership really is. So this is the property ownership life cycle when it comes to real estate. Um, so first-time home buyers, they're really fixated on the acquisition, right? How much does the house cost? How much does it cost to close? How much am I paying my agent? How much does it cost to kick off the loan? What they're not really thinking about probably is the upkeep and maintenance, and they're definitely not thinking about the disposition of the property. It costs money to give away assets. It's the extreme example could be like a piano, right? A piano might have cost you $3,000, but to move a piano, it would probably cost you about $1,000 to move it. Even if you want to give it away, no one would take it because they would have to pay for the movers. So that's an extreme example. But so obviously, the agents take a cut at both ends. Um, every single year, you have to pay for general upkeep. There's property insurance. Every single year, you have to pay the county so that they won't seize the property for action, and that's auction, and that's in the form of property taxes. Fun fact: mortgage comes from the French phrase mortgage, which literally means death pledge, and there's a reason why traditionally it's a 30-year term. This thing is for life. So at the very end, probate attorneys get paid if the sale of the property happens at death. If you're wealthy enough and there are estate taxes, and also there are potential non-exempt capital gains taxes, depending on when it was sold and what taxable events there are. So it's very expensive, right? Now let's shift gears here real quick. What is probate? Do you guys know, show of hands, how many people have gone through the probate process before? Um, anyone? Their parents or friends? Okay. If your client asked you what probate is, can you guys tell them what it is? Okay. So in general, probate is a court supervised process that has to happen when you hold assets in your personal name and you die. So let's say I buy a property and I take it in title. I take it as William Ha, a married man, as his separate property. I'm the only person on title. If I pass away the next day, that's technically and legally in my personal name. And to get that asset out and transferred to my son or a friend or anyone, it has to go through the probate process. So in probate, all your assets are pulled together. Creditors are then invited to file proofs of claims. Some are legit, some are not. The legit ones are paid. And then whatever is left over, if it's still solvent, it's then distributed to your heirs or beneficiaries. Heirs if you have no will, and then to beneficiaries if you do happen to have a will. So currently, the threshold amount triggering a full-blown probate is roughly $200,000. And for most people, most clients who give me a call, the thing that triggers a probate is typically the house. I'm talking townhomes, condos, like that ownership, because the median property value might be like roughly $1 million nowadays. That takes some in the probate territory. So the downsides of probate is that it's expensive, it's slow, it's public, and all the creditors are invited to file proofs of claims. It's slow as in it's 18 months slow. The fastest probate you could do is maybe 9, 10 months, and that's by statute. You need to give people time to file proofs of claims. And that's only if the probate goes well and there's no like issues, right? If there are issues, then the probate could last many, many years. People are fighting over things. It's public in that when you petition for probate, your address is on blast, your phone number is on blast. Anyone could find out on the court records how much you're getting when you're getting it. And then in the age of AI, like people are totally subject to scams. So anytime I file probate, I get at least 10 letters from real estate agents. How do they know that? Like how like it's automated, obviously. It's called farming. But my clients get random solicitation from banks that say, "Hey, would you like a loan?" And they call me, they're like, "Is this an official document?" I'm like, "No, it's not." But the information's out there, and once you file for probate, it's all out there. So creditors are invited to file claims. So it's mandatory that you invite creditors to file claims. The creditor that most people are actually worried about is actually the state of California through the Department of Health Services because of Medi-Cal. So the general rule is that when you're old and you're sick and you guys need Medi-Cal at a skilled nursing facility, they're willing to pay up to 100 days for free because you're poor enough to qualify, right? Or you do things to make yourself qualify. But if you happen to have something in probate and you do have a probatable estate, Medi-Cal through the state will come to put a lien or they will try to sue the estate to get paid up. So this is why a Medi-Cal lien exists. If you don't have probatable estate and you don't have to do probate, then they can't recover from you at all. So that alone for a lot of people is enough incentive to avoid the probate process. But that's a very, very common creditor, the state through DHS. Okay, so how expensive, right? So by law, people are paid a certain amount. So the probate attorney is paid 4% of the first $100,000, 3% of the next $100,000, 2% of the next $800,000, and then 1% of the next $9 million. That's how much the probate attorney is paid. The personal representative or the executor, and that's typically the person who will be hiring the attorney. It's often the surviving spouse or a child or a friend or something like that, or a beneficiary. They're also paid the same. So on a hypothetical $1 million estate, because they happen to have a townhome, and if I was hired, I'd probably get roughly 30 grand. The personal representative with the same. And this is if there's no extraordinary services. If there happens to be any litigation or any infighting, then we're just basically billing by the hour at that point. So the estate value amount, that threshold we're talking about, it doesn't account for any liabilities. So no one cares that you happen to have a $500,000 mortgage on the property. If it's worth $1 million, then it is $1 million, and you're totally in probate, and you're gonna have to go through this process. So because of this, because there's this pressure to pay off creditors, because there is this pressure from the probate attorney or from someone else, there's a lot of pressure to sell or refinance after paying unsecured debt. Even more so after Prop 19, because upon the death, unless the child moves into the house and makes it their principal residence, that property tax will be reassessed, the basis. So a lot of my clients, they are elderly. They're like 90 plus. They bought their house back in the 70s or 80s, and they might be paying, I don't know, $1,100 a year or something like that in property taxes. The fair market value of that property tax right now would be roughly $11,000, $12,000, on that property. So if you could keep the tax basis, that'd be ideal. But nowadays, that's starting to be less and less common. Okay, so pop quiz. True or false? Creating a trust avoids the probate process. So just show hands. True. True. Okay. And then who says false? Okay, so the people who answered true are gonna get really upset at me because This is partially a trick question. The reason why it's false is because it's 90%, 90% true. And this is because we need to talk about the mechanics of how a trust works. I'm going to spend this portion talking about why trusts are bad and why they could fail. I still sell trusts. I still push towards trusts, but you cannot blindly trust a trust, even when it's done by a lawyer, because the lawyer can make mistakes. They may not answer all questions correctly. They may not have spent enough time. And especially if the trust is old. If you have a trust that's 10 years older, um, you really need to read it. You need to understand it. If you don't understand it, at the very least, put the language in the ChatGPT, let it translate to you in basic language what it really means. Um, but you cannot trust a document that you don't read. So I've bought and sold 6 personal properties for my wife before, and every single contract I sign, I don't read it. I'm a lawyer, I don't read it. I don't care. I'm going to assume that the agent did the right thing, and that's how I went. And I guarantee you, 90% of my clients do the same thing. When I give them the draft of the trust, which happens to be between 40 to 80 pages, I could explain it night and day to them, but I guarantee you they may never have read the thing word for word. So just a warning, you cannot blindly trust a trust. Okay. Okay. So this is the number one common problem, that the trust was never funded. Okay. So Sophia and Leo, they set up a family trust in 2015, and they list the home as a trust asset in it. In the trust document, they say, yeah, we own this home. So Leo, the husband, dies in 2023, and then Sophia decides to sell the home and calls her favorite realtor, Vincent Chen, the only name she knows. And then when Vincent checks the county records through IgniteRE, he discovers that the home is still in Leo's name as his separate property. Leo has one daughter from a previous marriage, and then Leo and Sophia have no children together. Okay. So when the real estate agent delivers this news to Sophia and she talks to the attorney, like her heart sinks. This is her primary residence. And even though it's been transferred, even though she thinks that she created a trust, potentially it's not 100% hers. So by default, through the rules of intestacy, if it were just that, Sophia will own one half, and then Leo's child from the previous marriage would own one half. And let me tell you why this happens, right? When you create a trust, that trust document over on the right, just because the trust says we have a house in South Pasadena, this is the address, and just because it says this is my Wells Fargo checking account, this is the account number, just because it says that doesn't mean that the property is actually held in trust. Right now, in computer science, you have what's called a dangling pointer. These objects are inaccessible. So you have a house that's still technically owned in personal name under Leo, and then you have a checking account, for example, that's owned under personal name, right? What you actually want is you want to make sure that once you have the trust in existence, the trust agreement, you want to go ahead and do a grant deed or a trust transfer deed that says, I, Leo, transfer this property to Leo and Sophia, trustees of this trust that was created on December 12th, 2015. And any amendments there too, right? And you have to record that trust transfer deed. No one knows that this trust exists at all. Okay, so if you go ahead and try to sell this house, title will come back to you and say, there's no authority. Like this is like this looks like it's in Leo's name and it's going into probate, right? So whenever you create a trust, you have to make sure that the assets are fully funded and the assets are actually still aligned with the trust. And this is actually one of the most common problems when it comes to doing a trust. Many times when I have calls or meetings with clients who have done this in the past, I ask them, hey, like, who did the trust funding? Did the attorney help you do it? Did you do it? Sometimes banks, when they help with a refinance, they say, oh, it's in trust. I need you guys to take out a trust, put in your personal name, then sign the loan documents, and then put it back. And you think that's what happens. No one puts it back. The deaths happen. We're in probate. So What is Sophia's recourse in this case? So if the attorney did a good enough job, there should be certain avenues that other attorneys can pursue to make sure that this doesn't have to go through the full probate process. So aside from this option, there's something called a pour over will. So when people do a trust, they actually typically also do a will. The whole function of the trust, the whole function of that particular will is to say, hey, if there happens to be any assets outside of trust, I need you, personal representative, to put it in trust. Yes, it's still going to be going through the probate process, but at the very least, you can ensure that the disposition of the property will still be going through the trust. So that's one option. The best option, though, is something called a Heg step petition through Probate Code Section 850. And what this does is that it's still technically in probate, but it's much shorter and a lot less expensive. Basically, you're going to say, Sophia is going to say, Judge, I'm so very sorry. This asset's outside of trust, but we happen to have enough evidence in the estate planning documents that happens to illustrate Leo's intent that we want the asset to be in trust. In fact, we even have a general assignment that says everything I own shouldn't be in trust. And then even better, we have a grant deed that was never recorded, for example, right? So then the judge takes the petition, has a hearing, and then can declare magically, basically, that everything that the house actually does in fact belong to the trust, and it could avoid probate. And then with that order, you could then take it to title. Title say this is good. You guys go ahead and sell the property. So the thing is, you don't want to rely on this at all. This is like it's not the worst case scenario, but this is not the best scenario. And the reason why this is because when you do a Heg step petition, it's basically a lawsuit against any potential heirs. So there happens to be a second cousin, one first cousin once removed, and if the estate's big enough, I guarantee you, people are going to come out of the woodwork, try to challenge it, and then try to take the piece of pie. It likely won't happen for a $1 million estate, but if we're talking about things, worth 3, 4, 5, 6, it definitely would happen, and they'd want a piece of pie. So this is one way that that could basically save Sophia in the hypothetical. And then the second common problem is this right here. It's an outdated trust, in particular trusts that have not been updated in over 10 years. So older trusts do something called an A-B split, meaning the trust is split in half upon the first death. And I'll tell you why this happens in a little bit. So you got a married couple, it's split in half, and it's done for the process. It's done to try to minimize the federal estate tax impact, right? And what this does is that this plants a landmine in the form of capital gains in the future when the property is sold. And it also forces unnecessary complexity in trust administration. And that's the other thing I want to tell you guys about. Like people think that a trust is done, it's set, everything is perfect and easy, but that's actually the furthest from the truth. When you have a trust and the deaths happen, you have to do what's called an administration. You have to send notices, you have to give accounting. If there are beneficiaries, they have to know. If the trust is going to have distributions done over 20 years, then the trustee is going to have a lot of work to do, right? So let's just shift gears, step back, zoom out real quick. So the general tax issues when it comes to estate planning are these three here. Estate taxes at the federal level, income taxes in the form of capital gains, and then property taxes to the county that you pay every single year. So when it comes to federal estate tax, and I know that when we're talking about taxes, people, I definitely start losing people because it's a lot of numbers. But in general, the rule is this. Today, this year, when you die, you're actually able to give away up to $14 million tax-free. Anything over $14 million, it's taxed at 40%. That's the general rule. So if you're married, that doubles, it's $28 million, right? Today, there's something called portability applies. And what portability means is that what it means is that if the first person who died did not use up their $14 million coupon and given away up to $14 million tax-free, the surviving spouse could use that unused gift exemption to pass it on when she dies. That's portability, basically. So back in 2010, that didn't exist. Not only that, in 2009, the federal exemption amount was $3.5 million per person. So between not having portability and having a really low exemption, most people used it or lose it. And because there's this pressure to use or lose it, um, oftentimes a solution was that we just did a split. We did a one split, A-B split down the middle, so that at the very least, the first spouse can at least give up to their exemption amount. So this is what administering the old trust would look like if it was done today. So let's say, for example, at the first death, the house was worth $1.5 million. And then if the surviving spouse decides to sell it, she would get what's called a step-up basis because it is community property, which means she would potentially have no income taxes, right? And let's say the second death happens when the house is worth $3.5 million. And then all of a sudden she transfers everything to her kids through her trust. So the property is split in two under two separate trusts. When the kids go to sell it, they may not know that when they sell it, maybe 20, 30 years down the line, there's actually some additional capital gains taxes because the decedent's revocable trust split the estate in half. So because it's not all in one particular ball that's given to the kids, half of it does not get what's called that step up in basis. So let me back up for a second about capital gains taxes and step up in basis. So the whole principle and whole idea about capital gains taxes is whatever appreciates when you buy a thing, you have to pay taxes on it in the form of capital gains. So let's say, for example, you bought one Bitcoin at $1,000 back in 2014. And let's say you sold it today for 120. The capital gains you have is $119,000 because that's how much you gained. If you do a sale, if you execute the sale while you're alive, you get the capital gains like that. If you wait to give your stuff away upon death, then the IRS is willing to reset the basis to be whatever you sold it at. So that's why there's so much incentive to give things away at death as opposed to while you're alive. But what's happening here is that we're splitting all the estate in half, and we're doing two separate trusts. So the kids will then have this potential capital gains issue that wouldn't have been there if there was no planning at all, right? So let's say the husband and wife just had the property in joint tenancy. Husband dies 100% to surviving spouse. And then when she dies, the kids get it. And when they sell it, their assessment, the base is back to whatever the fair market value is of at death of the mom. So why does this happen? Why does this scenario happen all the time? And the reason why this is because when they hired the attorney to do it, they never read the estate plan or they never understood it, right? The attorney maybe did not explain it to them well enough, or maybe they just thought about it for about an hour and they thought it was done. And maybe there was never any follow-up between the attorney and client. And lastly, I think it's the over-reliance on trusts as magical documents. So I think even though I recommend trusts all the time, and I try my best to make it work, they're not magical documents. They actually rely on your current understanding of the law and your current agreement. And then another problem that I have is that the administration is done poorly, or you have really bad successor trustees. So a general trust structure is this. Let's say I'm a client, right? I'm the trust creator, otherwise known as the settlor. You also happen to have a beneficiary, someone who gets the assets upon my death. And then you also have somebody called a successor trustee, someone who manages the assets after my death. When I create the trust, I'm the trustee, the initial trustee. So you have these three roles that people play. When you create a trust, it creates rights and obligations. It gives people the right to sue others if there's something that goes wrong. So all trusts, they require notices, taxes, accounting, distribution, right? So when you have someone that you appoint that's going to be a bad trustee, this will cause issues. And trust administration is actually not free and easy, cheap. If you have a professional trustee do it, it's basically what an attorney would charge at, $300, $400 an hour. Um, and also, if there are issues that happen at the trust administration, that's actually more that you have to pay. So I had a woman who came to me in my office. She was tasked as successor trustee. Her husband died maybe 6 years ago or something like that. And she was not she was not the first wife. She was probably the third or fourth wife. And then the kids were not her kids either, right? So you kind of see what the issue might be. You have a successor trustee who is not very sophisticated, and then the beneficiaries are already very, very adverse to her. So the moral of the story is that in that 5, 6, 7 years, she spent, at least $500,000 of their money. Of course, the husband left her money as well, but she basically is causing a lot of issues. And what are the kids' recourses? Their recourse is that they sue her if she ever has any assets that they can seize, right? They have to do it. So it's a civil thing. It's really hard to enforce people to do certain things. So whoever you appoint as a successor trustee, you have to trust them, and there have to be some sort of trust and checks and balances to ensure that they do it right. The whole idea is that when you do a trust, what you're trying to do is you're trying to um, assert your control post-death, basically dead hand control. If you don't need that control, then maybe you don't need a trust. So, for example, if I create a trust and I want to ensure that my money is paying for tuition, I could use a trust, right? If I just want to give it to them outright, then maybe a trust is actually not necessary. So, really, living trusts are never complete. So, I think the general rule is that if if I were to meet with a client today and we do the signing and we're done, I would tell them, you know what, ideally, I would like to talk to you every single year, right? Um, but if I don't talk to you every year, maybe at least every couple of years. But the reality is that most people don't talk to their attorney ever at all, and oftentimes the attorney is either retired or dead. So a lot of trust admin clients who call me, they say the first question I ask them is like, why didn't you call the attorney? Like, what happened to them? Um, Oh, they retired. Oh, they're dead. So you need to, if you do have a trust currently, my suggestion would be that you touch base with the attorney every couple of years because it's that important. Life changes so very quickly. People change very quickly. Um, and then friends who you consider your friends now, they also change very quickly. They may pass or they may do something you don't like, for example. So if not a trust and if not an attorney, then what, right? So the state of California, through the state legislature, has always had solutions for people to handle estate planning issues without necessarily using a trust, without having an attorney. So this is some of the options available. So as of this year, there's something called AB 2016. I wouldn't really bank on it. All this does is that it ups what you could transfer in real estate up to $750,000. In the past, um, it was $50,000. So the whole idea behind AB 16 is that 2016 is that if your property is $750,000 or less and you died on April 1st of this year or later, you don't have to go through the full-blown probate administration. You could do what's called a summary administration, and it would take months as opposed to years. And then the attorney that you're paying, you're basically just paying what they would charge for the process. So maybe $4,000 to $5,000, right? I could go into that in detail more. Transfer on death deed, that came out in 2016. I actually like this a lot. Um, the California statutory will, this is not going to avoid probate, but this is actually a really great tool to have to do other things if you happen to be in probate. The statutory power of attorney, and you guys might know this one, but that just basically allows you to appoint an agent to act on your behalf while you're still alive. But once you're dead, it's gone. Then lastly, beneficiary designations on all your accounts, like your checking accounts, savings accounts. Okay, so the reality is that most people don't have that much money. I mean, most people go into probate because they happen to have a house that happens to be worth $1 million or something like that. Um, but sometimes people have a real estate worth less than that. I know that this is kind of weird to say, but in much of California, a lot of single family homes are actually worth 750 or less. Um, and I guess today a townhome condo might be roughly that right now. But the whole idea is that the threshold used to be around $55,000. Now, after this year, after April 1st, you're actually able to do a summary administration if the home value that's a principal residence is 750 grand or less. It's like I said, it's a simplified probate without a statutory fee. It's completed in months as opposed to years. So, like I said, you shouldn't bank on this, but this is an option to avoid the full-blown probate if it happens. So if you guys do get a call from a client who says, "Hey, my mom died," what you might want to ask, I'm not trying to tell you guys to give them legal advice, but you might want to ask, "Hey, like when did they die? Did they die after April 1st?" If they died after April 1st and the home happens to be under that, there might be an ability to bypass the traditional probate process. So this is actually my favorite when it comes to DIY solutions that the state has. Has anyone heard about this document? Okay. So the whole idea is that since 2016, um, owners of real estate is able to record a deed that transfer the property on their death, much like you would be able to at a bank account, your checking account. You could say, "Bank, I would like to give this to my daughter upon my death. This is her name." You could do the same exact thing when it comes to real estate. It would only, it won't really make any sense to do it when you have co-tenants. And then when you happen to have a joint tenancy, it's the person who's last to die. Would a revocable transfer on death deed really work? It is revocable, which means that if you happen to change your mind, you absolutely could just do that. But this totally avoids probate. All it requires is just two witnesses and a notary and your signature. And then once you're recorded, it's on the chain of title. So when you do pass, the beneficiary would then do an affidavit, record the death certificate, and you should have enough stuff to clear a title to be able to sell the property. So because this is a post-death transfer, you'll automatically get a step up in capital gains basis, and it's not a taxable event. So this is actually a great tool to have, especially if the estate is simple and if there aren't too many beneficiaries, for example, and you know for a fact that people won't fight over things, right? I would say most of my clients like probably fall closer to this, where they're elderly, they don't have very much stuff, but they happen to have a house, and they have like one child or two children who get along. Um, but of course, one thing I might recommend is that if a person who you help close today are a single person, they're likely not thinking about estate planning, but you know for a fact that they actually might be able to utilize something like this up until they are ready for estate planning. This actually can save their family a huge headache because it would avoid the probate process. It really just costs $40 to record this deed in the county. So I think if anything, this is a really low bar and great benefits for it. So the downsides to this is that when you transfer property, any property that's transferred through this is subject to unsecured debt. So if there's any credit cards or something like that, the beneficiaries would have to take two unsecured debt. And like I said, it doesn't sever joint tenancy. It does nothing to the joint tenancy. The joint tenancy would still apply. But if this deed happens to be recorded and the last to go happens to be the person who did that deed, then it could transfer. And then this is what it looks like. The second page didn't come through for some reason, but it's basically literally a two-page document. You do the property description, which you get from the county, and then you list the beneficiaries. And then on the second page, if you could see, it would literally just be a signature line, a notary, and also two witnesses that signs on it. Once you have it, you record it. There's no pre-core required because it's not a present interest gift at all. There's no transfer done until the death. Okay, so this is the California statutory will. So back in the 80s, the state of California all thought, you know what, like Lawyers are hard to get to. Let's go ahead and make a fill in the blank will for people to use. So let's go ahead and codify it in law and make it basically fill in the blank. Um, so back in the day, print shops would have this, stationery shops would have this, but oddly, most people don't know that it exists today. They would rather pay LegalZoom to do a free basic will and pay the company when they could do the same here. It literally is you basically just sign the box that you want to happen. And at the very least, you get to nominate the guardians for your children if they happen to be under 18. And I think that's like the number one thing, the number one benefit to using the statutory will. So this won't avoid probate, but at the very least, it would allow you to waive the bond requirement for the personal representative to serve, which is actually a huge um, relief. And it also allows you to nominate guardians for your minor children. So if you have nothing, but you happen to have assets, um, at the very least have this, right? Or at least have a will. Um, and if you happen to be in a situation where you know that death is very imminent, as in like days or hours, this is totally an option that you could use to do a will. It's online, or it's actually in the law books too. So this one you might be familiar with. It's the power of attorney. I think a lot of people are actually really familiar with this document, but basically the power of attorney allows you to appoint someone else to act on your behalf. So for example, let's say I am in the military, I deploy, but I also want to close escrow. So what I do is I sign a power of attorney for my wife, um, or a real estate agent or something like that, and say, hey, this person has the signature authority to sign to sell this house on my behalf. Even while I'm abroad or somewhere else, they could do that and could still close. This is a very, very powerful document, but it's often held to high scrutiny because it's the number one document that people use to commit fraud. So if you or your clients do use a document like this, you have to make sure that you have enough authority to back it up, either additional letters to say that this was done with intent. Oftentimes, people don't have the capacity really, and they force a person to sign. It is possible to sign even by X or by Mark, so long as there are witnesses as well. But this is a very common document to commit fraud. And lastly, you could do beneficiary designations. So Bank of America, Wells Fargo, any institution that you have where you have your assets, you can say that you want a beneficiary to take over upon your death. So if you guys have assets anywhere, like you might want to check to see you already have this available. This will make sure that the asset will go through to the beneficiary without going through the probate process. So if you know for a fact that your kids need money, you don't want that money to be locked up in probate, this would be one way to give them some liquidity. But all institutions has this option. So what are the downsides of doing this without a trust, right? So overall, I think it's better than doing nothing at all. The thing is that there's no control when it comes to assets given to minors. If you give your child outright $200,000 in your brokerage account and they're 18 or they're just turning 19, what do you think is going to happen, right? They're going to go and buy things and they might not be able to spend wisely. Um, and there's also no future creditor protection for beneficiaries, meaning if they happen to be in a divorce or a bankruptcy, or if they commit torts and they get sued, whatever money that they have in their personal name would be subject to creditors. So if you leave things in trusts and when you pass away, it becomes irrevocable, there's a way to shield those assets from creditors. And then if you do it this way, you might have an unequal distribution to heirs and beneficiaries. Maybe you want some more fine-tuned control for certain people because certain kids may need more help than others, right? Or you may have someone is very dependent on you on their day-to-day living, and you know that they can't fend for themselves. So you want to make sure that that person might benefit more. And then the more extreme case is that someone is disabled and they rely on public benefits. And one way to ensure that they keep the public benefits is to do what's called a special needs trust, so that they could, at the very least, still benefit from money without being rendered ineligible for public assistance. So, who should realistically do this? Okay, so I feel comfortable doing this for myself if I were to do it this route. I think if you um, if you would like to do estate planning and you know that you need to do it, but you haven't gotten yourself to see an attorney or at least try to do any of these DIY solutions, then at the very least, do a transfer on death deed. I think that's very simple enough. At the very least, ensure that your checking accounts have beneficial designations, right? I think that could do so much to avoid probate. But to go that route only, and you know for a fact that you're gonna go that route, it would basically have to be a fairly simple estate. And you have to have the mindset that you want to learn estate planning fully and thoroughly. Estate planning is not something that you just see an attorney, get it done in 50 minutes, and then that's it. So basically, a self-learner would be a good candidate for something like this. But I think it's a good thing to do is just to ensure that you have something in place, not nothing in place. So I know that was a lot. Thank you so much. This is my direct email, direct phone number. I am on Instagram. If you guys want to book an appointment with me to talk, this QR code would lead you to the website where you book a call. But I am here for questions, and I know it was definitely a lot. I covered a lot that's not the traditional estate planning presentation. Right. So the question was, if a person happens to be on Medi-Cal and they happen to win the lottery and they happen to buy a house, what can they do to ensure that their home is protected? So Medi-Cal law is actually in a state of flux right now. So as of last year, Medi-Cal actually doesn't look at what your assets are to determine eligibility for Medi-Cal. It's mostly your income, which means that you could happen to have a house right now today, be really, really sick, apply for Medi-Cal, and qualify based on your age or your disability, for example. So it's still possible to have a home and still be a Medi-Cal, but they're actually looking at changing this law. So this is in a bit of flux. But currently, Medi-Cal, their policy is that they are only allowed to take what happens to be in probate. So if you want to ensure that they can't put a lien on the home or sue the estate, just make sure that there's no estate caught up in probate. Just make sure you avoid probate and Medi-Cal can't take from the state. So that's that one solution. And I think, like I said, that aim itself is worth lots of money. I mean, you could look at liens every day and you see things for 100 grand all the time. Yes, next question. I can hear you though. It's okay. Yeah.
Goes to reassessment of the property, about 3 to 4 in the siblings. So one of the siblings die, and then the beneficiary, obvious, the kids kick in for their siblings. So the question is, the reassessment, how much? Because let's say for 1.5 million total, ballpark. So each one siblings get, let's say, divided by 4, you know. The bottom line is they worry about the reassessment and who's supposed to pay. Is it only the one that create the probate?
Okay, so the question is, I believe, a Prop 19 question where the parents died and there are 4 siblings and they're worried about reassessment and county property taxes. Second home. Oh yeah. Okay, so they know for a fact that there's going to be a reassessment already. So, and all 4 kids own it equally? 25% each, maybe? Okay. Hypothetically, so in that case, there will be a reassessment, and it's basically a reassessment at fair market value. So if all 4 are entitled and all 4 literally own it, they would all be responsible for the property taxes. If they don't pay, then eventually the county will figure things out. But
Would there be any ballpark, like 33.5% each one, the reassessment? How do we know? Is it going to be assessor office?
well, the assessor doesn't care. They as long as it's not paid, they're gonna try to put penalties on it. So basically they should figure it out is what
So
it
is that
is.
the only solution better is sell?
Um, well, I mean, so this is not really a legal question. This is definitely a personal question for them. It's super nuanced. I really don't know, but like I said, like anytime anyone dies, when there are property taxes involved, there is a lot of pressure to sell. So I think a lot of my clients, they would sell in this situation because, the money is more valuable, especially if it's a second home that they don't want to deal with. Um, so it really is up to them. Um, like if they could swing renting it out, that'd be amazing. But if they can't even do that, then maybe selling is actually the best. That's a really personal question.
Exactly.
Yeah,
The last question is the capital gain tax.
yes.
Yeah. So I saw something about like 450, which is
So that's just a hypothetical. So how property gains taxes work is that if you're a child or any beneficiary who happens to inherit the property, um, if the person who died owned the property outright 100%, if it's given to the beneficiary, then if they sell it immediately near the date of death, their cost basis of how much they technically acquired it for will match up to what the fair market value is. So instead of being like given a gift of like $1.5 million and it's taxed on that, you're basically given a gift and the IRS is willing to say, yeah, you bought it for about a 1.5 and you sell it for 1.5, so there'd be no capital gains taxes. So the capital gains taxes analysis really depends on what happened in the decedent. So really what happened, it really matters what they did. But if it's straightforward where they own the property 100% and they happen to give it to a child 100%, then there'd be automatically a step up in basis. And that step up in basis, it's given to everybody, even without estate planning. You don't need to do a trust, you don't need to do a will. That's just the IRS rule. So don't be misled into thinking that you have to do that to avoid any taxes when it comes to capital gains. Yeah. Did that answer your question or?
yes and no. Maybe
Yeah.
do you suggest that we need to talk to tax CPA?
A tax attorney can help with that. I
Well,
mean, but like I said, in a hypothetical scenario where, let's say my mom buys a house in the South Bay for $200,000 back in the 80s. And then let's say she dies today, right? And she makes me the owner 100%, and it's now worth 1.2. If I call one of you guys to sell it for 1.2, I pay nothing on capital gains because the IRS will treat it as though because she held the property until she died and because the transfer doesn't happen until death, the IRS is willing to say, oh, yeah, you should sell it for 1.2, but we'll make it so that it seemed as if you acquired it for 1.2 as well. So instead of you acquiring it for zero as a gift, um, you get a step up in basis. If she gave it to me while she was still alive, that's when the capital gains will 100% occur, and I would have to pay the difference in the gift amount versus how much I sell it for. So it really depends on when the gift occurred, death or while they're still alive.
thank you so much.
Thank you.
Thank you so much, William,
Thank
to
you.
give us so wonderful and informative section. We are so benefit. My question, I am currently has a irrevocable living trust already,
Yeah.
but I figure out, I don't know how to do. My daughter's name changed, last name changed because Mary and address changing. So for those data, we need to be changed, be reviewed. Do we need to re-record it and how do we process it? Can you let us understand what is processing and how long we need to do that if we ask your help?
Okay, so the question was that she currently has a revocable living trust and that she has a successor trustee who has a name change because of a marriage. So generally speaking, it all comes down to what the assets are and whether or not you're able to sell it and liquidate it, right? So the main adversary you're going to have will be the title officer in escrow, whether or not they would greenlight the transaction or not. Whenever you do a trust, the attorney likely did what's called a certification of a trust, which is basically an affidavit that says, yes, a trust exists. These are who the trustees are. These are who the beneficiaries may be. These are the powers that the trustee has. So the whole idea is that when you do have a trust, it's not supposed to be a public document. It's a private document. So when you go to escrow with the trust, you don't give them the actual trust. You give them what's called a certification of the trust. And for people who do like sales with trust admin, you guys must have seen this already. It's just a 2-page document from the trustee that says what powers they have, who they are. So when it comes to name changes and people being married, so long as you could prove the fact that the name change did occur, say like a marriage certificate or something like that, I don't think that should be an issue at all. I don't think it may warrant the full-blown change or restatement in the trust. Although if it is older, maybe it would be beneficial to at the very least look at it again. When it comes to asking any attorney for help for trusts that they did not draft, typically many attorneys would not just simply do an amendment because they would assume the liability that was done in the past. What they would want to do is to do a restatement. A restatement is basically just a redo of the entire trust, and they would charge at fair market value. And then I'm guessing you're asking how much I might charge for a review or something like that, or okay. So for a review, I would basically just kind of look at things. I could charge a flat rate fee of $600 to kind of tell you if I see anything wrong. But when it comes to actually doing a full-blown trust, for a married couple, the fees start at $4,500 flat. And then for a single person, it's $4,000. I know that there was an estate planner about 4 months ago. She was the old mayor of, I think that's a good deal. I think she was charging $1,800 flat for a married couple. So if cost is important to you, there is a wide range, and you could certainly interview a lot of attorneys for free and get a free consultation. So, and it's not indicative of what the quality of work is. It's more the quality of the care, attention, and time spent with you. Because I have had certain clients come to me with trusts done from other attorneys who gave them no time of day, maybe spent 20 minutes. They don't understand what the trust says. And everything was done in Cantonese. And they charged them maybe $1,000. And it was a great trust. I'm like, this person did everything right. And it was really cheap. So yeah, just keep that in mind. Yes, next question.
Thank you. Thank you so much for the information. And for the transfer on death, the TOD, and then I tried to get the form notarized, but I was told nobody want to notarize the form. I don't know why.
So the question is that she had a transfer on death deed. She went to try to notarize it, but nobody wants to notarize it. Was it just one notary that you went to, or have you tried more than one notary?
To ask to notarize.
Did you ask them why? Did you ask them why?
Oh, they don't want to. I don't want to notarize this form.
Interesting. Okay. Notaries would do it. You just have to find the right one. Worst case scenario, you go to UPS or something like that. But my notary would do it just fine. Like it's a fairly routine document. I think partly is because maybe they're still not used to it because it is relatively new and in the legal world. But this is no worse than a power of attorney. I think a power of attorney is way worse of a document to notarize. I mean, worse. So.
Okay, so for the second question for the witnesses, and then the person is must not related to the owner, or anyone can do the witnesses.
The question is, who should the witnesses be for a transfer intent upon death deed? The answer is they should not be related to the person who's granting the property. So even though I'm trying to tell you guys that it's actually a great solution, it also really depends on the family dynamics. If you know for a fact that it's going to be a high conflict situation because the kids don't get along or there are different sets of kids, a transfer upon death deed is still, you can still use that document to commit fraud or pressure people through undue influence. So to answer your question, yes, they should be someone who's neutral. Ideally, they don't know them that well, and they're not related, and they're not going to be an heir or beneficiary.
Okay, thank you.
Yeah, you're welcome. Yes.
I did talk to some trust attorney before. They told me just generally that the transfer on death deed, some of the title company may not like it. So they didn't do like the explanation. So does that mean if you use this form when you are selling the property, probably the title won't let you to do the recording? Is there
So-
any risk?
So the question is, the question asker asked said that she spoke with other attorneys and said that certain title companies may not like the transfer and debt deed. And yes, I think it's the reason why they may not like it is because they're afraid that certain things are subject to undue influence, meaning the person may have been pressured into doing transfer and debt deed. So yes, that is a concern. But the alternative is that there's either it's bare title ownership where it's going to be subject to probate, or at the very least, you have some form of layer that would redirect the asset away from the probate estate. But truly, a transfer and death deed is by law, is by statute. So long as the execution is good, like all executions through a power of attorney or even like a buy-sell agreement with you guys, like so long as the person has capacity and they signed and it was witnessed and the witness could testify that the person who signed is in good mind, they have capacity and they understand what they're doing, then if it has to go to court, then it will go to court and the property can still be transferred that way. So it all comes down to the capacity of the signer, really. And that's why there are 2 witness signatures required to witness the transfer. So just in case something were to happen, they could do it. So it really depends on the risk level and who did it, right? So it's not very common. People do reach out to me, and sometimes I do a transfer on death deed for them. And I would imagine that is good because my name's on it and I've interviewed people. So yes, I think that is a concern, but it ultimately comes down to who signed it and whether or not they have capacity.
My question is, I and my wife have a house, no living trust, okay, only under my wife's name. In the future, if I and my wife pass away, I have 2 children. Can they take over the house without sell the house? Just transfer the name, just take over the house under their name.
Okay, so the question is that you currently have a house with your wife and it's not under trust, it's held in personal name, and you guys have 2 kids. And the question is, can the kids just live there without transferring title? Is that correct?
Yeah, after we pass away,
Yes.
my wife, can they get the
Can they get
the
title?
house, get the house under their name
I see.
without selling it, you know?
I see. Can they transfer title after your deaths?
after the death.
Okay, my question is it under your wife's name only?
Wife,
Both,
husband,
joint
and
tenants? Okay.
Yeah,
So,
trust.
right, so after the first death,
After I
right.
both dead.
Okay, yeah.
Both dead.
Yeah. Yeah, so, yeah, totally. So let's say you guys are in a car, you guys are both in a car and you guys get in a major accident, you guys are both gone immediately. So that house is gonna go through probate.
Yeah, go probate.
They'll go, okay, so your kids have to call me or somebody else, say, hey, my parents died, and it's worth over 750?
What's the,
Okay, yeah. So yeah, this is gonna be full-blown probate. So they're gonna call one of the probate attorneys, say, hey, my parents just died. The probate attorney says, hey, okay, give me the death certificate, give me all information, let's open up probate. The court hearing date is the first court hearing, that's 1 month later. And then we close probate maybe 20 months out if everything goes well. And then after 20 months, then title can change to their kids.
then trying to get it without selling it, no
Right. So yeah, you don't have to sell in probate. You could just simply transfer the title. But the issue is if you happen to have debt and you happen to have creditors, those guys have to be paid. If the estate doesn't have the money to pay those guys off, they're going to try to go for the house. And that pressure might be enough to sell the house. So, so it really depends on what the whole issue is. One of the cool things about trusts is that in trust administration, when the person dies, there's no statutory mandatory requirement to give notices of your passing, and the creditors have 1 year to sue. If they don't sue in that 1 year, then the trustee could forever say, you missed the deadline. The statute of limitations passed. You can't sue anymore. Your suit is barred. So, whereas in probate, you have to give notices to everybody. You have to invite creditors' claims. So in my trust administration clients, I tell them, hey, up to you. If you want to close everything out within 4 months, you could give notices to everybody, but why don't you just go ahead and wait, save potentially $5, $10, $20, $30,000 and wait to see if they sue. If they don't sue within a year, then maybe you could save that additional money. So it really depends on your creditors. Going back to your question.
Only the mortgage, if they keep paying the mortgage monthly, if they keep paying the mortgage monthly, so
Yeah.
it should be no problem, right?
So with your mortgage, it's a secured mortgage, so they're going to get it no matter what. It's a lien. So they're not unsecured creditors. But yeah, I mean, so long as the mortgage is paid, the home won't get foreclosed on. But I'm talking about mostly pressure from, say, Medi-Cal through 3HS or your American Express or something like that, like things that might force your kids to sell. And also the attorney's fees too, right? Do your kids have an additional 30, 40, $50,000 to pay people in the process? Will they have to refinance the house to pay these people? So there's just a lot of pressure to either refinance or sell. So, but yes, to answer your question, they can just transfer title in the probate process as part of the final distribution in court. Thank you. Yes.
Okay, William, thank you.
Please.
Last question.
Once you create a trust,
Yes.
how often do you recommend to update? And the second question is, who are the possible creditors?
Gotcha. So the question was, once you create the trust, what do you recommend in terms of updating the trust? And then the second question, can you repeat one more time about who the possible creditors are? What do you mean by that?
You kept mentioning about the creditors.
Yes.
Who are these people? Who are they possibly be?
I mean, like, do you have a credit card? Do you carry a balance on your credit card? So, for example, that the credit card company, or the state, like I said, through Medi-Cal with DHS, you're healthy now. I mean, you're not 100 right now, but there will come a time in a day where, when you're closer to death, there would be a period of incapacity, right? And your kids are like, well, what should we do? Like, we can't. Do we take care of him? Do we have the capacity to take care of him? Can we take advantage of Medi-Cal to put them in a skilled nursing facility for 30 days, right? And that could be that for a lot of people, that is a potential creditor. It's the state, really. So if you are carrying unsecured debt in the form of credit cards or contract agreements that you have with anyone, and sometimes these creditors, you don't even know where they come from. It could be a business transaction gone bad with a business partner, and they'd like to sue your estate. It could be a car accident you caused a month before you passed away because you were not driving very well. They could come from anywhere. But to answer, okay, so I think I answered that second question. But the first question, like I said, I think it's ideal to be thinking about this stuff frequent enough. But there are triggering events. You know, like sometimes kids pass away, or sometimes kids get divorced. Sometimes kids get married. Anytime that there's a legally significant event that happens is probably when you may want to change certain roles that you've nominated for people to occupy in your trust. But I think if I had to give you a number as to how often you should be doing the meeting with an attorney, I think 3 to 5 years is safe enough. Like I said, the biggest change since 2010 was really the portability and also the estate tax exemption. So currently we could give away, because the passing of the Big Beautiful Bill, you could give away up to $15 million. Most people don't have $15 million. There's only a handful of clients I have that have an estate tax issue, but that's relatively new. Prior to COVID, that number, the estate tax, was actually trending downwards, right? COVID changed things up, made it really high, and it was supposed to sunset at the end of this year, but then this bill made it so that this is a permanent change. So laws change all the time, but I think every 5 years or so would be safe. But I honestly think you're never safe. I think, like I said, you can't blindly trust a trust. You have to know what it says, and you have to kind of keep up if you really are concerned about it. So you're welcome.
Well,
Thank you.
thank you, William, for your so informative and important presentation. On behalf of the West San Gabriel Valley Realtors, we present a certificate to